In this lesson, we're continuing our discussion of the First Amendment free speech analysis. Specifically, we're going to focus on content-based speech regulations. Basically, what do we do when we go through all of our steps and we determine that we do have the government regulating free speech activity within the scope of the First Amendment? There's no threshold speech issues. We get to step number 4 and we determine that, hey, the government is actually targeting an objective related to suppression of expression, right? In other words, the government's regulating speech because of the substance or message the speech itself communicates. So we have a content-based speech regulation. What do we do? Because up to this point, we've pretty much discussed every other permutation. We've talked about what happens when conduct is being regulated that's outside the scope of the First Amendment. We've talked about what happens when the state action requirement is not satisfied. We've talked about what happens when, there's threshold speech issues that are at issue. We've talked about what happens when we get to step number 4 and we determine that the government's objective is actually unrelated to suppressing freedom of expression. And we talked about the content neutral side of the analysis and these different forms of intermediate scrutiny we apply in those situations. Pretty much all that's left to complete our understanding of the First Amendment free speech analysis is content-based regulations. And the good news here is if we get through all of our steps, we go through steps 1, 2, 3, we get to step 4, and we determine that we have a content-based speech regulation. Really, our starting point rule is pretty easy. Generally, content-based speech regulations are subject to strict scrutiny and are held unconstitutional. Remember, if we're on this side of the board, this is the highest level of scrutiny in our free speech analysis that the government is going to be subjected to. This is where the government has to provide the most justification in order to prevail. In order for their speech regulation to be upheld as constitutional under the First Amendment, they're going to have to provide really high levels of justification. And most of the time, we're going to see the government really can't prevail. They're not going to have enough justification with content-based speech regulations. This is like Texas v. Johnson, okay? Now, the thing that we're going to really want to focus on and look out for are the exceptions. Basically, when can we be on this side of the board and the government actually still can prevail? When can the government essentially pass content-based speech regulations that are going to pass constitutional muster? And we'll see that the main kind of exceptions we want to think about are these categories of unprotected speech. Okay, we have inciting imminent lawless action, fighting words, obscenity, defamation, and some types of commercial speech, basically like false and misleading advertising. Okay, so what we'll see is if we're on the content-based side of the board, okay, we've gone through all of our steps and we're confident that we have a content-based speech regulation. What we're really going to want to do as our starting point is say strict scrutiny is going to apply unless the activity that's being regulated by the government falls within one of these limited categories of unprotected speech. The good news here is, in terms of all of the nuance in our First Amendment analysis, in my opinion, this is one of our more kind of bright line areas. And of course, there are other ways that the government can have a content-based speech regulation that is ultimately upheld even outside of these categories of unprotected speech. But for our purposes in law school and the bar exam, when we're thinking about content-based speech regulation, the only way I've ever seen this tested where the law is ultimately upheld is when it falls in one of these neat categories: inciting imminent lawless action, fighting words, obscenity, defamation, and some types of commercial speech. Basically, the Supreme Court has just said that these categories of conduct, of speech conduct, are just unprotected. They're almost outside the scope of the First Amendment. The government is allowed to come in and regulate in these areas. The hard part And that's what I'm talking about with like the bright line idea. We have these bright line categories that have really been identified by the Supreme Court. So if we can determine that the conduct that's being regulated by the government does fall within one of these categories, then okay, the government is going to be permitted to regulate in those categories. The hard part is determining whether the conduct being regulated actually does constitute these categories. Does the conduct being regulated by the government actually constitute inciting imminent lawless action? Does the conduct being regulated by the government actually constitute fighting words, obscenity, defamation, some forms of commercial speech? So really what we need to do next is break each of these categories down in detail, kind of element by element, looking at the case law, exactly how we define each of these. So if we're looking at a constitutional law fact pattern and we're on this side of the board, we're deciding, okay, look, the government is regulating speech because of the substance or message it communicates. In other words, the government is targeting an objective that is related to suppressing freedom of expression. How do we analyze that? Well, remember, we start with strict scrutiny, but if the government is in one of these categories, it's regulating speech that falls within inciting imminent lawless action, fighting words, obscenity, defamation, some forms of commercial speech, then it's outside the scope of the First Amendment. It's unprotected speech, right? The First Amendment only protects basically protected speech. So if it's unprotected speech, the government's going to be able to come in and regulate in those areas. So we need to define exactly what each of these areas are. So what I'm going to do here is I'm going to go ahead and just erase the whiteboard so we can clear up some space, and I'm going to get up like kind of all the requirements for each of these categories up on the board, and then we can break each of those down line by line. So I'm going to go ahead and do that, and then I'll be right back. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else. in any of the other online resources that I found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.